Greetings and welcome to Fraudulent Conveyances. There we go. Fraudulent Conveyances and Transfers. Diminution of debtor to the detriment of creditor. And welcome, Somatic Earth. And everyone else is here. Please hit the like so that everybody knows that we have arrived and we're ready to get into this. So, on the first part of this, we spoke about what fraudulent conveyances are, where they might apply. Then we looked at why they might be used as a course of action within the legal system to find remedy. And today we're going to go over how they are actually implemented in the system so that we can see more clearly where the rubber meets the road. That being said, before we even begin, I just want to remind everyone this broadcast is for educational entertainment purposes only, not to be used for anything of your personal, financial, legal, lawful, or otherwise life choices, actions, activities. Please don't do this at home. That being said, let's continue. We will have at our ready Black's Law Dictionary 9th edition to make sure we leave no word behind. And with that said, make sure the chat's working here good. Definitely please hit the like so everybody knows we're here. It seems the last notification didn't go out. And give everyone time to get here. Let's get right down to it. Okay, we're going to be going over, this is from the 2nd edition American Jurisprudence. Oh shoot, what happened here? One moment. There we go. 2nd edition, November 2022 update, and this is section 169, complaint or petition, generally. Generally, to state a cause of action under a statute patterned on the Uniform Fraudulent Transfer Act, which we went over in part 1, the plaintiff must allege that the existence of a debtor-creditor relationship and the existence of a claim, 2 elements, to survive a motion to dismiss a fraudulent conveyance claim, a creditor need only allege that it is a judgment creditor of the transferor, in that the fraudulent conveyance has deprived the transferor of funds which the creditor could use to satisfy the debt. Interesting here. Let's look at this observation here, because as American jurisprudence does so well, let's break down the more complicated statements here that are pretty densely packed, yet full of important facts. Observation. Speculative and conclusory allegations will fail to state a cause of action for a fraudulent conveyance. For instance, allegations in a complaint for a violation of the Uniform Fraudulent Transfer Act are insufficient to state a claim where the plaintiff fails to allege what sections of the Act have been violated and offers only a one-sentence legal conclusion to support its allegation. Interesting here. So speculative and conclusory allegations will fail stating your cause of action for fraudulent conveyance. So a complaint for a violation of the UFTA is insufficient, and you have to allege what sections, and you can't be offering a one-sentence legal conclusion to support your allegation either. So the one-sentence legal conclusions rarely are sufficient in the first place, but that's a great observation. As you can see here, these are practice tips in a sense that allow you to kind of have a better sense of the way things operate in the real world when they do hit these types of causes of action, and whether they can actually pass or fail to have standing. Under a notice pleading rule, a plaintiff's complaint adequately states a claim under a statute, which provides that the conveyances of property may be voided upon showing an intent to defraud creditors and others, though the complaint actually alleges another statute which requires that the plaintiff be a creditor on the date the property was transferred. Since the complaint gives sufficient notice of the plaintiff's claim to enable the defendants to answer and prepare for trial. Interesting here too. Footnote 5, that's from Lewis, Lewis versus Blackman, 1994, North Carolina. So let's see here. A bill is not multifarious because it seeks to set aside as fraudulent distinct conveyances of or encumbrances on the defendant's property in favor of two or more different persons. Wow, that's an old case here from 1923 of Wilson versus First National Bank in Alabama. We're on to section 147. Avertments as to particular matters. So these are our allegations here as to particular matters. There is authority to the effect that fraudulent conveyance claims must be alleged with particularity. As we just saw back before here when we're looking at this observation here, that it's just a complaint is not sufficient to state a claim where plaintiffs allege what sections have been violated in only one sentence to conclude the supports allegations here. So we want to have particular. All right, let's go here. The particulars of our allegations. There's authority to the effect that fraudulent conveyance claims must be alleged with particularity. That goes back to 1999 and apply New York law. Interesting. On the other hand, courts have found a substantial difference between an action for common law fraud and a statutory action for a fraudulent conveyance. And we saw in section 1, we went over the distinction between those two and the bar for bringing a cause of action. As a result, many of the considerations that lead to the requirement of pleading with particularity in cases of common law fraud are not present in an action for a fraudulent conveyance. Generally, a pleading is good under statutes based upon the Uniform Acts if the avertments, as tested by the pre-existing law, are shown to be sufficient, the particularity, right, sufficient to state a cause of action. For instance, a complaint in an action under the Uniform Fraudulent Conveyance Act to set aside a conveyance need not allege that the property conveyed was not a homestead or otherwise exempt. And as we saw before, that the Uniform Fraudulent Conveyance Act has actually been replaced a lot by the Uniform Fraudulent Transfer Act. And there are some interesting elements within the Conveyance Act that were more applicable to the common law that are not in the UFTA. So let's see, was there anything else besides, no, just these case holdings. So we're on to section 171, avertments as to particular matters, standing of party to sue, excuse for laches or delay. Remember, we went over laches, which is, this could actually override statutes of limitations, but they're ones that cause the harm for the excess of delay. In a suit to set aside a fraudulent conveyance, a complainant must show by his or her complaint or petition that he or she is a person protected by the fraudulent conveyance statute, which, in the usual case, means showing that he or she is a creditor of the transferor or is suing in behalf of creditors, and that he or she has a right to institute and prosecute in the action. However, the failure to allege that the complainants are creditors may be obviated by an answer substantially admitting that they are creditors. Interesting here. May be obviated by an answer substantially admitting that they are creditors. Complainants are creditors. Failure, all right, so let's get this. Failure to allege that the complainants are creditors may be obviated by an answer substantially admitting that they are creditors. So I guess the evidence overrides any kind of allegations here, of course. If the avertments apparently disclose latches, the complainant should explain the delay and show why it should not have the effect of putting him or her out of court. So again, the latches sometimes gives the possibility of going beyond statutes of limitations based on the doctrine of latches, I believe it was. That was in part 2 of Fraudulent Conveyances and Transfers. The complainant should explain the delay and show why it should not have the effect of putting him or her out of court. For this purpose, the complainant should show when and how knowledge was obtained, in order that the court may determine the question whether a timely and reasonable effort was made to ascertain the facts. If apparent latches is thus not explained and rebutted by the allegations of the bill, a demurrer will lie. So there it is, 1894, when they like to use words like demurrer. And as to limitations in latches and fraudulent conveyances, 152 to 158. You can take a quick look at that if we want. We're on 171. Let's look at 152 to 158. Is there anything there on latches that might benefit us right now? As we did take a deep dive on that on the last episode. All right, here we go. 158. Commencement of running time or statutory period. Effective concealment of fraudulent conveyance. Where a debtor, for the purpose of defrauding his or her creditors, conceals a conveyance or transfer his or her property to another, a statute of limitations specifying the time within which a creditor must bring an action to set aside such conveyance or transfer is generally told, and the statutory period on the creditor's cause of action does not commence to run until the creditor discovers, or by the exercise of ordinary diligence, might have discovered the debtor's fraudulent acts. If the creditor thus seeks to postpone the date from which the period to be computed, generally with some authority to the contrary, the obligation devolves upon him or her to allege and prove facts that show concealment of the fraudulent transfer and lack of knowledge thereof on his or her part. Although the statutory period of limitation on a creditor's action to set aside a fraudulent conveyance or transfer starts to run on the date the fraudulent instrument is recorded, starts to run that date. Some courts find that the mere recordation or registration of a fraudulent conveyance on a certain date is just one circumstance bearing on the creditor's actual or presumed knowledge of the fraud and is not conclusive so as necessarily to start the running of the statute. So it seems that there could be more than one factor or circumstance here in that. Let's get to 152 very briefly here. I love these observations. Let's look at this really quick here. The appropriate limitations period on a cause of action under some statutes is borrowed from the statutes of limitations applicable to the underlying claim which made the plaintiff a creditor in the first place. Interesting here. This is where your statute of limitations may ride too. Thus, for instance, a fraudulent conveyance action brought by a Chapter 7 debtor attorney's former client in order to enforce the client's rights under judgment is a legal malpractice action, would be subject, like the underlying malpractice claim itself, to a 3-year statute of limitations. Oh, wow, and has to be brought within 3 years of the challenged transfer. Interesting there. And I think we went over 152 on the last one. We're just going to briefly see what the heading is here. And it was generally on who forces the claim. Let's look at the observation here really quick. The statute of limitations. Yeah, okay. The statute of limitations does not have the effect of converting a fraudulent deed into a valid deed by reason of the lapse of the prescribed time. Instead, it simply forbids the right of action for relief on the grounds of fraud. Hence, if the question as to the fraudulent character of the deed arises in any way other than in such an action, there is nothing in the statute that forbids its being assailed for fraud. Thus, one who has made out a prima facie case for the recovery of land is not prevented from attacking as fraudulent a deed that is set up in defense, because the time for bringing in an action to set aside the conveyance as fraudulent has expired. Wow. Interesting there too, in that observation of statute of limitation in recovery of land. So another interesting footnote here for an observation, courtesy of American Jurisprudence. All right, let's get back to where we were from this digression. And it was 171, I believe we were at. There we go. And here's where we are. 172. Avertments as to particular matters, pursuit of legal remedy, judgment, and execution. Since, in accordance with the generally recognized principles of equity jurisprudence, an available remedy at law must be exhausted by the creditor before a court of equity will assist him or her to lay hold of property of the debtor that has been fraudulently conveyed and is not subject to execution. It is only by the exhibition of such facts as show that these remedies have been exhausted that equity jurisdiction attaches. Interesting here. This dates back to 1908. If the recovery of a judgment at law is a prerequisite to the right of a creditor to invoke the aid of equity to set aside a fraudulent conveyance of property by his or her debtor, the complaint or petition must aver that the judgment has been recovered, where, in addition to the recovery of a judgment against his or her debtor, the creditor must have issued an execution on the judgment. The creditor must allege that the execution has been issued and returned unsatisfied, or that the enforcement of the execution was prevented. And that's from footnote 7. That's from sections 144 and 145. Here we go. Section 137. Averments as to particular matters, fraud or lack of consideration, transferees, participation, or knowledge. Of course, averments or avertments, however you I'm not too good on the terminology of the speaking here, but this is just basically your allegation or what you're stating as a fact here for the case. So it's just another way of saying that. I'm not too sure why they're using that as opposed to allegations, but I guess this is the technical term when we're speaking about conveyances. So let's proceed. Of course, this wouldn't be a bad time to check out what Black's Law has to say to this, because it is in an A, so we should be able to find it very quickly. All right. It's just catching up with the scrolling here. Here we go. All right. It should be there pretty quick. Ours. And here we come to almost there. Look at all these kind of audits they have here. Field audit, event-driven audit, environmental audit, double audit, independent audit, internal audit, correspondence audit, desk audit, compliance audit. Audit, 15th century, a formal examination of an individual's or organization's accounting records, financial situation, or compliance with some other set of standards. Compliance audit, an audit conducted by a regulatory agency, an organization, or a third party to assess compliance with one or more sets of laws and regulations. Desk audit, review of civil service position to determine whether its duties and responsibilities fit the prescribed job classification and pay scale. All right, let's continue here before I digress any further. All right. Let's go over here. We must have passed it. Nope. Okay, here we go. Averment. Averment. So they have it only one way here, so we'll have to say it like this properly. Averment. Noun, 15th century, a positive declaration or affirmation of fact, especially an assertion or allegation in a pleading. So there we go, a positive declaration or affirmation of fact. So that's a positive declaration or allegation in a pleading. Plaintiff's averment that the defendant ran a red light. So it's a positive declaration. I get it. The plaintiff's averment. So we have an immaterial averment from the 18th century, an averment that alleges something in needless detail. Immaterial averment. This is a good term for us to know now. An averment that alleges something in needless detail. A statement that goes far beyond what is an issue. This type of averment may be ordered struck from the pleading. And there's a negative averment, which is strange because averment's a positive declaration. So a negative averment is an averment that is negative, but in form, but affirmative in substance. And that must be proved by the alleging party. An example is a statement, she was not old enough to enter into the contract, which is more than just a simple denial. Ah, wow, that's a tricky one. Negative averment. And there's averment of notice, a statement in a pleading that someone else has been properly notified about some fact, especially in special actions of see notice. All right, I've gone too far down this rabbit's hole. Let's continue back to where we were. All right. So let's see here. In a suit to set aside a fraudulent conveyance where fraud must be stated with particularity, fraud may not be pleaded by name simply. Instead, the pleading must contain a statement of facts or circumstances demonstrating fraud or from which fraud may be inferred. As to the intent with which the debtor executed the conveyance, which is sought to be set aside, while there are decisions to the effect that it is insufficient to allege merely that the transfer was made with the intent to delay or defraud creditors, other authority concludes that an allegation that the transfer was made with intent to defraud creditors of the grantor is a sufficient averment of fraud to support an attack upon the transfer as having been fraudulent. Some authority has determined that in order to avoid a conveyance as having been fraudulently executed, the bill must expressly charge, as our bill of exchange, I believe here, that the instrument was executed with a fraudulent intent, although other decisions are to the effect that such an averment is not essential. So a positive declaration, it was done with fraudulent intent. In certain jurisdictions, under the constructive fraud provision of the Uniform Fraudulent Transfer Act, fraud need not be alleged because it is presumed, and intent is immaterial. 1997, liquidation of Medcare HMO. Interesting. Illinois. As to the transferee's knowledge of or participation in the transferor's fraudulent design, it is sufficient in a complaint or petition to set aside a fraudulent conveyance to allege either that the grantee received the conveyance with a knowledge of the fraudulent purpose of the grantor, or that the grantee was a mere volunteer who paid no consideration, or only an inadequate consideration, under a statutory provision declaring that a conveyance which has been made without a fair consideration is fraudulent if made by a person who has been rendered insolvent thereby. The complainant need not allege that the transferee had knowledge of or participated in the transferor's fraud. Moreover, it is not necessary under a statute declaring void a conveyance of the property made or obtained with an intent to defraud creditors to allege that the transferee knew of the fraudulent intent of the transferor, which sounds a bit different than in the case of the corporation or insurance as we read previously. So that would be one big distinction we're seeing here, to me it seems. So, as the transfer's intent to hinder or delay creditors, generally see Section 9, which we went over in Part 1. And looks like we have here a 1972 case, 2012 case, great. An estate administrator failed to allege that the final grantee of real property had any notice of the administrator's purported judgment lien on the property, or that the grantee had engaged in any fraudulent conduct as required to state a claim for a fraudulent conveyance. Failed to allege that the file had any notice. Okay. Interesting there. This would be an interesting case to look into. Well, on that note, it looks like we're going to take a break from that anyways. Perfect timing. On that note, I'd like to thank everyone for showing up. This has been a great, a roundup of these fraudulent conveyances and transfers. I believe I'm going deep into the rabbit hole here, but we've gone over all the foundational terms, and I think by understanding the foundations of such actions as this, it helps us better navigate this sea of confusion for many, and it seems to be a lot of stupidity and ignorance too that accompanies it, and this will help us navigate those waters with a lot more confidence. And so I salute you all for being here and going with me on this journey, and I hope you all have learned something from this as I have and I hope to see you all on the next one. Peace out.